more knowledge about the area of estate planning, probate, and various issues with real estate, which is obviously your specialty. You know a lot more about that than I do, but I know a lot about the titling and that sort of thing, which is really important. It's kind of funny, I thought of when I first bought a house many, many years ago. I was very young and naive, and I remember them asking me when I bought the house, how do you want to hold title? It was my husband and I said, I don't know, I heard there's a good way and a bad way. I want the good way. Okay, what exactly does that mean? You know, I mean, to this day I remember that and think, they must have thought I was so dumb. But honestly, they didn't know to tell me, educate me what's the good way and what's the bad way. So, obviously there's people out there that don't know that. So I want to talk about titling issues, but I also want to give kind of a basic overview of estate planning and what is a trust and why do we want people to have trust, and then what happens if you don't have a trust and some other estate plan, whether it's through the mechanism of a trust or some other way. So I'll talk about all those. But real quick, just want to tell you a little bit about my background. I actually was a nurse long before becoming an attorney, worked as a nurse for many, many years, and mostly in the intensive care unit, so I saw a lot of life and death stuff. At a certain point, I had a couple of issues. I had a car accident where I was rear-ended and got a kind of a neck injury, and then on the job doing a lot of lifting as a nurse, I kind of finished the job on my neck. So I was unable to continue working as a nurse, in the hospital. So decided to go to school to do something else, and I had heard about legal nurse consulting, and I thought, what a great thing. I could use my nursing background and some legal stuff. And as I got into a legal nurse consulting program, I found out that they were kind of glorified paralegals, and I got a little frustrated with that. And I just kind of said one day, I've been answering to doctors my whole life. I'm not going to start answering to lawyers. I'm just going to become a lawyer. And I don't know what I was thinking, but I immediately found a school that I could get into right away, and I started law school, and it took me about a year of things like criminal law and civil procedure and all these weird classes before I kind of went, what was I thinking? I'm a nurse, this is weird. But by then I was a year into it, so continued on, and while I was in law school, I honestly had never had any encounter with a lawyer before, so I really didn't know much about the profession. But while I was in law school, my mother died suddenly. We were not expecting that. There was a medical malpractice issue, so I had to have a lawyer for that. My brother is also developmentally disabled, and he had a conservatorship. My mother was his conservator through the court. So I had to get an attorney to represent me to become his conservator. So, and then I forget, I had a couple other, just the estate planning issues, because my mother had a very complicated trust, because she had an attorney that I don't think was super competent. So her trust splits into 10 separate trusts, and she nominated Mechanics Bank to be the trustee, and they took one look at it and said, we don't think so. So I had no trustee. So anyway, I had to get a lawyer to represent me to become the trustee. So I was just kind of dumped into all of this stuff. And this was all while I was in law school. So as I came out of law school, I wanted to do something with my nursing background, but I was having a lot of personal experience with estate planning, probate, trust, courts, all of that stuff. So it kind of led me in that direction. I think that's kind of how a lot of us get our careers, is something happens in your life and sort of directs you that way. So that's how I got into estate planning, which later morphed into more elder law because of my nursing background. And so that's what we specialize in now, is both estate planning and elder law, protecting seniors that have health issues and getting their estates in order, potentially getting government benefits to help cover the cost of care, because as we age, we generally have a lot more expenses for our health care. So anyway, so that's what we focus on. We do a lot of probates, we do conservatorships. Those are the court cases that are kind of like estate planning gone bad. And our goal is always avoid court. I always tell people, at all costs, let's avoid court, because court is not a fun place to be. It's expensive, it's public, everybody sees all your dirty laundry. I can remember sitting in front of my attorney when I was doing the conservatorship for my brother when I did my very first accounting. First of all, I didn't know you don't round off numbers in an accounting. Well, you don't. So I'm trying to do this accounting totally wrong, and the court came back saying, the court investigator saying that they didn't approve of what I did, and I was just sitting there with my lawyer just crying, saying, I didn't ask for this job. I'm just trying to help my brother. If they can do a better job, let them do it, And I was just beside myself. And I'm telling you now, years later, I sit across from clients who are saying the exact same things. And I can really relate because court is not fun. You've got people overlooking everything that you've done, questioning you as if you're stealing money when all it is you just didn't know you don't round numbers or whatever. In order to avoid that court experience, it's really important that you have some basic understanding of the estate planning and how we can avoid that. So there's a number of documents, and honestly, it's not as complicated as a lot of lawyers make people think because, they like to, sound really smart. There really are only about 4 primary documents that we are concerned about in estate planning. One is the will or the trust, and we usually will have both. If someone has a very small estate, they don't own any real property, they have less than $150,000 is generally, that's the cutoff for going to probate. If they don't have that much, we can often just do a will for somebody that says, when I die, here's who's my executor, they're going to manage everything, and here's where I want my estate to go. Pretty straightforward, and most of us have heard of wills. If somebody has more in their estate, where they have real estate of any value, which obviously is what you guys are interested in, and or anything greater than $150,000. Now you can have certain pay-on-death designations, like life insurance has a beneficiary designation. Your retirement accounts have beneficiary designations. So you can have certain accounts that say pay on death. You can hold accounts jointly with somebody else so that if you die, it just automatically goes to them. But we're just looking at basic estate planning. If you have a fairly sizable amount of money, which most people in this area do, then we want to do a trust. And the trust actually acts as a will, but it acts in a little more complicated way. The trust is a legal entity that actually owns property. So right now, I own my house, I own my bank accounts, I'm an individual. If I die, the court has to step in to make sure my money goes where it's supposed to go. And the primary reason the state is concerned about that is because of taxes. They want to make sure that real property is out there with somebody owning it so that they'll pay their taxes. Because if there's property out there that nobody owns, nobody's paying taxes. So that's kind of the backstory of why they're concerned about probate. But essentially, I die, we need to probate my estate to get it to wherever it's supposed to go. If you have a will, all that says is that the court will probate your will. So whatever your will says, the court will enforce it, but you're still going through the whole probate process through the court. When you create a trust, you're creating a legal entity that can own property. Just like I as an individual can own property, a legal entity can own property. So when you create the trust, you transfer your property, whether it's your real estate through a deed, or your bank accounts by going to the bank and changing the title on the accounts, that sort of thing. You title it in the name of the trust. You're still the trustee of the trust. So you're still in charge of your money. You're the beneficiary of your trust. So it's still your money, but it's owned by this legal entity. So when you die, the legal entity has a plan for the succession. So I die, I was basically like the CEO of my trust, the trustee. When I die, the next trustee just steps right in. We don't need the court to come along and say, we need a new owner. We already have an owner. It's the trust itself. So that's why we want, especially with real estate, but even big bank accounts, we want that titled in the trust. And it's not enough to just create a trust. I've seen people where they created trusts and then they never funded them. The trust can only handle what it owns, just like I can only handle what I own. If it's not my bank account, there's nothing I can do with it. Same thing with the trust. If it doesn't own the property, it can't do anything. So we always want to create the trust and then do whatever legal documents to transfer. Again, with real estate, it's generally through a grant deed or a quitclaim deed, basically transferring the ownership to you as the trustee of your trust. Then when you die, there's an affidavit, death of trustee, you've just died, and a new person comes in, signs that saying, I'm now the new trustee, and then they can take over and be responsible for the sale of the property and that sort of thing, totally without any court involvement, totally private. They have full authority to sell the house, encumber the house, distribute the house, whatever the trust says is supposed to happen. So that's the basics of just getting it to the next generation or wherever your property is going to go, is that will or trust. When we create a trust, we generally also create a will that we call a pour-over will that just kind of catches anything that was left out of the trust. So if you forgot to title an account in the trust, you just didn't fund it properly, or you intentionally left something out, The will just says anything that's not in my trust goes into my trust when I die. So it all funnels through the trust. So that's kind of your end of life plan. But a trust also can work during your life. I mean, as I said, you're in charge, but if something happens to you and you're incapacitated, and we are living longer, and we're seeing a lot more dementia and a lot more other health reasons that people can't manage their property anymore. They can't sign documents. And again, while you're living, if you have a successor trustee, they can just take over as now the acting trustee. Even though you're still alive, you're still the beneficiary of it. It's still your money, but you are no longer the one managing it. So whoever the current trustee is, that's the person who has the legal authority to buy, sell, encumber, do all the things that they would be doing with property. So those two documents are kind of end of life, but also during life. But the other two documents during life that we always want to make sure that everyone has, and this is everyone from the age of 18 up, it's not just for old people, is a power of attorney and a healthcare directive. And they're legally called a durable power of attorney, which just means that once you become incapacitated, it's durable, it continues on, it doesn't go away. So we have a durable power of attorney and an advanced health care directive. Those two documents serve during your life. They end when you die, but during your life, those are the documents that say, here's the person who has the legal authority to step in my shoes and sign documents, make decisions, talk to whoever, the power of attorney being for financial issues, and the health care directive being for health care issues. But as I said, those are the two documents that give someone that legal authority without going to court. So if you, as an adult, once you're over 18, your parents can't act for you anymore, so we get a lot of this issue with kids going off to college and they're over 18 and something happens and mom and dad can't really handle it anymore because legally they're an adult. So, but all the way through the end of life, if something happens to you and you don't have a trust or something's not titled in the trust or whatever, and you need somebody to pay your bills or talk to Social Security or the IRS or whatever, if you don't have that legal document, then what happens is whoever's trying to help you has to go to court and get the conservatorship. And the conservatorship is the legal authority for somebody to do what you could have appointed them to do voluntarily, but you didn't, and now it's too late because you can't sign documents anymore. So that's the process through the court while you're alive, the conservatorship process that we always want to try and avoid. That process it requires going to court and saying, oh, this person is incapacitated, there's nobody around to help, I need the legal authority to pay the bills, and there's a big, long list of legal hoops you have to jump through. So, and it's very, very expensive. So again, if you have those two documents in place, someone can make medical decisions. If you get in a car accident, there is somebody that can make those decisions, sign those consents, and the doctors will honor that, or pay your bills, whatever, from the financial perspective. So those two documents are important for every single person. Whether you have a will or a trust, honestly, I'm not as concerned with that, although it's obviously your final plans is important. But what I deal with more is the living people who now have issues with incapacity for whatever reason. They can be young, they can be old. I mean, as a nurse, I saw very young people with horrible accidents, illnesses, all kinds of stuff. We don't know what's going to happen to us, I mean, all it takes is pulling out of that parking lot, and somebody smashes into you, and your life has changed forever. So having those documents in place just protects you from having all of the other heartache and headaches that will happen if something bad happens to you. So it's just being prepared. So the other thing is, as far as selling your house, oftentimes a power of attorney does have that authority to do the sale of the house. It's a little more cumbersome because that power of attorney actually the original has to be recorded with the county recorder, to show that chain of title that person actually had the legal authority to sign for you. And I know title companies are not real happy about signing, documents signed by powers of attorney. So we generally would prefer things are in a trust and the trustee or the successor trustee can do it. It's a cleaner way of transferring title that we generally don't have as much pushback from title companies with the insurance and the county recorders and that sort of thing. So, but that's how we make sure that somebody has that authority to make decisions, sign documents, do whatever needs to be done, both during life and after life, and then ultimately distributing your estate to wherever it's supposed to go. So that's just kind of an overview of estate planning in a nutshell. The other thing I kind of wanted to talk about is the titling of houses. Like I say, I worked with with a realtor that didn't have a clue what was the good way or the bad way. Obviously, as an individual, you can own property just as an individual. If you have a trust, then you title the property in the trust. I recommend anybody, a single person that owns property, when they're buying it, you tell them you need to title it in your trust. And if you don't have a trust, you need to get a trust. Because what happens if you don't have a trust, you title it in your name, and when you die, that's going to go through probate. Probate is that legal process that happens after death. So the conservatorship is during your life. After death, it's the probate process. Probate, just to give you a general idea, the fees in probate are crazy. It's a staggered percentage of the value of the estate. So what happens is it's 4% of the first $100,000. So it's $4,000 if your estate's worth $100,000. The next $100,000 is 3%. So now for a $200,000 estate, you're at $7,000. For the next $800,000, it's at 2%. So 2% of whatever amount, and then beyond that, it's 1%. So it goes lower, the percentages, as your estate gets bigger. But when you total all that up, for just a house in this area, you're looking at $20,000 to $30,000 in probate fees. That's just to do the probate. Then you've also got whatever other expenses there are in handling the distribution of assets and again, totally preventable by having that trust. So for single people, just really, you can't emphasize enough, it's important they have a trust. And if they don't, they need to talk to an estate planning attorney or an elder law attorney, depending on their age and what's going on in their lives. But that's something that if you can advise people, you're doing them a huge service, because a lot of people don't have any clue. And they don't realize that putting a trust together doesn't cost anywhere. It's a fraction of what that probate's going to be. So, and it's going to last for the rest of their life. This isn't something, we got to do it now and we're going to do it again next year. It's kind of a one-time investment. Now, once you have a trust, you do have to upgrade it periodically, but the big expense is putting it together in the first place. After that, it's just making sure, if one of my beneficiaries died, well, I need to address that, or whoever was supposed to take over moved away, those kinds of changes. Sometimes there's changes in the law that we need to address, but overall, once you've got that trust and you've titled the property, you're pretty safe. So that's for single people. For couples, there's basically three primary ways that couples can hold title. One is as joint tenants, one is as community property with right of survivorship, and one is in a trust. So with joint tenants and community property, a lot of times people don't know the difference, and that's when I was talking about the good way and the bad way. That's what I was referring to. I just didn't know it at the time. Joint tenants, when a couple owns property as joint tenants, when one person dies, then for tax purposes, for capital gains tax purposes, they get a half step up because that person only owned half because they're joint tenants. They're co-owners. There's a right of survivorship, so it automatically goes to the survivor. But from a tax perspective, the only part that went to the survivor is what's eligible for the step up in cost basis. Whereas if you have it in community property, again, with right of survivorship, it goes to the spouse, but you get a full step up in cost basis because as community property, you both own the whole thing. So the IRS says, okay, the whole thing comes up in value to the current value. So when I'm talking about capital gains tax and step and cost basis, let me kind of backtrack and tell you what that is. When you buy an asset, you have a set cost basis. This is what I paid for it. When you sell that asset, that's now your sale price. The difference in that, and generally it's gone up, especially with real estate, is your capital gain. Now there's write-offs to that, but essentially to the extent that you have capital gains, you pay taxes on. For real estate, for your primary residence, you can actually write off $250,000 of capital gain for an individual, or $500,000 for a couple. It's basically $250,000 each. So if your house has gone up less than $500,000, then you're not going to have a capital gain tax. You may have a capital gain, but the exemption brings it down, so there's no tax. But anything over that $500,000 for a couple or $250,000 for a single is going to be subject to capital gains tax, which is anywhere between 15% and 20%. Which I have seen people that around here that bought their houses back when they were $50,000 and they're now worth $1 million. We are talking huge capital gains. As a matter of fact, one of my staff was telling me yesterday we're going over some finances for a woman who's now in care and we're trying to get her benefits. And she's looking at it, and last year she paid I think it was like $200,000 or $300,000 in taxes. And I'm going, what? She sold her house. She sold her house for something like $1.5 million. And from what I understand, as she was researching, whoever bought it just recently sold it for $3 million. I guess it was a fixer-upper. But anyway, this woman had bought it for really low, sold it for, so she paid a huge amount of tax, and then whoever bought it, I don't know, maybe it's a 1031 exchange, but whatever. But the point is, with the capital gains tax, is if you got gains and you've already used up whatever exemptions, you're going to pay tax on that. And so that's where if a person dies owning property, they get that step up to the current market value. So if I bought my house at $50,000, but when I die, it's worth $500,000, and then it continues to go up, and now it's worth $750,000. Well, now my cost basis is $500,000 for my kids, and when they sell it, they only have $250,000 rather than all the way from my initial cost basis. So you get that step up in your bottom line basis, what you're starting with. So, as I said, with joint tenants, you're only getting a half of a step up. So, again, you get people, especially some of these older couples that have owned these houses for years and years, they started off really low. Even when one spouse dies, they only got a half step up. They're still going to have some pretty hefty capital gains if they go to sell the house. So that's why it's better to hold it in community property. When we hold it in a trust, we're generally holding it as community property within the trust. So if it's titled in the trust, that's generally enough to give you that full step up in cost basis. Now, there are other states in America that don't have community property, but here in California, that's the way it works. So again, holding title as a couple, we recommend it's either community property with right of survivorship. If you don't have a trust or you insist you don't want a trust, that's the second best thing. Don't really want joint tenants. In some cases, you'll have people that maybe are unmarried. They're not a couple. In which case, sometimes joint tenants is what you want. Sometimes it'll be like a family house that's gone down through the generations. The kids inherit it, and they say, no, it's not going to our kids. It's going to go back to the siblings, so that whatever. Joint tenancy would be the way to do that because it automatically goes to that other person. So that's the issue with joint tenancy is it just goes to whoever the other person on title, or if there's multiple people, goes to whoever in equal shares. As opposed to if you hold it in tenants in common, and we generally don't see that with couples, but non-couples, tenants in common means I own my share, you own your share, we're in common, but we're separate individuals. So my share goes wherever I say in my will or my trust, and your share goes wherever you say. It doesn't automatically go to each other. So again, we often get these complicated situations where parents have died, they have a bunch of kids, and then we get, because we do a lot of elder law, we get people that are older who now the kids have died and now they had kids, and so we've got multiple ownerships here, which some of them have them in trust, some of them don't. Gets very complicated. Clearly, if people that are joint owners in any way, if they have a trust, it goes smoother to the next whoever it's supposed to go to, just a much cleaner title so that when they do want to sell, it's like, okay, we know exactly who owns this share, we know exactly who owns this share, as opposed to if somebody died and now that their share has to be probated through the court and it's going to go to who knows who. Nobody has the legal authority to sell that house because that particular share of the house doesn't officially have an owner till it's been probated. Gets really, really complicated. And again, totally avoidable by having a trust and every individual that is a co-owner having their own trust saying my share goes to my spouse or goes to my kids or goes wherever it goes and your share goes wherever, so that the joint owners are me as trustee of my trust and my sister as trustee of her trust and or whoever. So that's kind of the better way to co-own if it's not spouses, is that you each have your own trust owning your share. I think that's the primary stuff I want to talk about titling, and I am going to open this up for questions, so certainly if I brought anything up that you're going, what are you talking about, feel free to ask, or if there's something that you came in here thinking, oh, I sure hope I can find out something about this, definitely ask that too, because I'm here to answer questions and I want to meet your needs. Just a couple other things. There's fairly recently, I think it's been about 2 years, time flies, and I never know year to year, but a couple of years ago they did institute a transfer on death deed, and so a lot of people are hearing about that, and it sounds really good, and it's a revocable transfer on death deed, and people are trying to use that to avoid having a trust. It just says it's a revocable deed, so they do a deed saying, on death, it transfers to my kid or whoever it goes to. It's a great concept because it avoids probate. You don't have a complicated trust necessarily. But unfortunately, it's very limited too, because if the transfer on death, the person who it was supposed to go to dies, now we're back into a probate. If the person who owns the house, when they died, they had debt, there's a big issue with, okay, this property is transferring to this person, who's paying the debt? So there's a lot of issues with those transfer on death deeds, and so I generally do not recommend them. The last I heard, most title companies don't even want to touch them because there's so much liability after the fact. After it transfers, creditors coming back and, trying to sue to get their debt paid. So I generally don't recommend them. They're kind of the poor man's estate plan, which oftentimes doesn't work. The other thing is with a trust, if you have a disabled beneficiary, and I hate to say it, but there's a lot more disabled beneficiaries these days. Not necessarily disabled, but we're seeing a rise in autism. We're seeing a lot of kids that cannot manage money. And in a trust, you can specifically say, I want this kid, my responsible kid, to get their share outright. But this kid who's really kind of not doing well or has all sorts of creditor issues, I want it to stay in a trust. And maybe if you have a disabled kid that's getting government benefits to pay for their disability, if they inherit a bunch of money, they're going to lose those benefits because they're needs-based. So they say, oh, you got a bunch of money. You don't need our government money anymore. So when you run out of money, come back to us. In the meantime, you run out of money because with their disability, they're spending really fast. So with a trust, you can actually set it up to have a special needs trust, which is a special kind of trust that Social Security and all the government agencies will honor, saying it's not that beneficiary's money outright. So that way, when they're looking at do they still need this benefit, so if they're on these government benefits, that money will not be counted against them as you have too much money because it's not legally theirs. It's in this separate trust with very strict limitations as to how that money can be distributed. You can't do that on a transfer on death deed. You can set that up with a will, but if you have a complicated enough estate that you want that, you're really better off doing it through the mechanism of a trust. So again, beneficiary situations, oftentimes just talking to people about their family. They mention they have an autistic kid, which, I have a disabled kid right now. He's in Utah. I just got him there, so I know what that's like. But you need to do special planning for those kids. And this is an opportunity where you're working pretty intimately with families, and when you're talking to them about this house, what about their family? Are you seeing that they have a disabled beneficiary or some spendthrift kid that that they're talking about? That's an opportunity for you to say, hey, have you done estate planning to protect that kid? Because again, there's ways we can protect them from inheriting and losing these benefits that they could potentially be eligible for. So the mechanism of the trust is really a flexible way that we can kind of morph it depending on the situation of the beneficiaries and really save everybody a lot of money, a lot of heartache of trying to deal with, okay, this kid is now inheriting money and they're on drugs and now guess where the money's going or whatever. So I did want to mention that. And at this point, let me kind of open it up if anyone has any confusion you want me to clear up from things I've said or something else that you're wondering about. Any questions? Yes.
Okay, on the step up.
Yes.
I had somebody ask me, his wife had died, and so he wanted to get an appraisal, I guess, to go back to when she died.
Right.
Is that a possible? So we
Yes.
would go back to the value, and then he would only pay the tax between then and now.
Right. So we get that a lot, where we have spouses come in and their spouse died whenever. Sometimes it's a long time ago. Sometimes it was last year. But essentially, that step up in basis, the new cost basis, is based on the date of death. And so we often, contact realtors, and obviously, I think some charge for it, most don't. Most of you would use it as an opportunity to, develop a relationship. Obviously, this person is hopefully going to sell at some point. But you would then go back and look at the comps for that particular period of time and come up. Now, we can get an official appraisal with an appraiser. I have had no problem with realtors doing it and the IRS saying, oh no, that doesn't count, as long as you have legitimate comps and that sort of thing so that you can show how you came up with this number. You didn't just pull it out of a hat. An appraiser costs a lot of money to clients, and honestly, if they don't need it, as I generally say, work with your realtor. It's work for you, and it's part of marketing but you can charge for it. Some people do. But yeah, absolutely, you want to get that basis. Now, the other thing on when you're getting those comps, part of what's important is how did they hold title. If the husband and wife held title as joint tenancy, your appraisal at that point is only going to be the half step up in cost basis at that point. But that's not as much your issue. You just need to know what's the full value of the property through your comps. And then when they're actually looking at what is my basis going to be, that's where we would then look at the title and say, was it joint tenancy? Was it community property? But depending on that, it's either that's the full basis or that's half basis, and the other basis was their original purchase price. The other thing you can take off of capital gains is improvements. Now, not your basic upkeep of a house, but any improvements, capital improvements you've done, all of that, cost of sale, realtor's fees, all the closing costs, all of that comes off of your capital gains. Does that pretty much answer your question?
Got it.
Perfect. Question in the back.
Yeah, but regarding her question, so what was the benefit to go back? For example, I have a case scenario right now, right? And the husband passed in '96. She passed in 2017.
Okay.
So in that scenario right there, what's the benefit of going back in time when the father died in 1996?
And he's asking a question about the couple where both of them are now dead. One died many years ago. One just recently died. Again, if the property went to the surviving spouse so that they owned it completely at the time of their death, then you don't need to go back, because at this point they own the property, they get a step up at that point. It would only be if you have a surviving spouse that still owns it, that's maybe going to sell it or whatever, that issue of what was the basis back then. Yeah, if you hold it long enough and everybody dies owning the property, then it doesn't matter, because whoever dies as the owner gets a step up on whatever their ownership interest is. Okay? Question here.
I'm sorry, I didn't quite understand the difference between joint tenancy and community property.
Okay.
So how does the step up work? Can you explain?
Right. Okay. The difference between joint tenancy and community property. Joint tenancy, you technically only own half of the interest, whereas community property, you both co-own the whole interest. So as joint tenants, you only get a step up on half of the property, because that's the property that then moved to the other spouse. Whereas if it's community property, both of you own the whole thing, so you get a step up in the whole thing, even though there's now a survivor. But as community property, the whole value is now at the current fair market value, as opposed to joint tenancy, where you have half of it is at the current market value and half of it was at the purchase price. And then you add those together, and that's your basis. Does that make sense?
Yeah.
Okay. Yes, another
So
question in the back, and I'll get to you. Yes.
Just piggybacking off her question. So for example, if let's just say the step-up basis on a community property, I'm just trying to follow the train of thought, right? So you go up to 800. Let's say they bought it for 72,000 40 years ago, which they did, right? And it goes up to say 800, 900,000. Once the wife passes, right, community property, and the benefit to coming up in the cost basis is so that you minimize capital gains,
Right.
as opposed to say taking $1.2 million from the 72,000. That's a huge gain.
Exactly.
Gotcha.
So if a surviving spouse sells the house and you didn't have that step up in cost basis, they're going to have huge capital gains tax. Whereas once you show that step up, that whole tax goes away. And as I said, that can be 20% of the value of it, which can be hundreds of thousands of dollars. A huge hit. One here, and then I'll get to you. Yes.
General question about the living trust. How often do you need to go back and revise some of it, because of course the kids grow, your properties might change.
Right.
And is it better to change the original one or go ahead and start a new one?
Okay, the question is, how often do you revise the trust, and is it better just to start over periodically or just revise the old one? I generally say about every 7 years or so, if nothing major's happened, just take a look and just kind of think about, okay, has any of my beneficiaries changed? Has my successor trustees who's going to take over, has that changed? Have they moved, died, married, divorced, whatever? Have new people been born that they, like grandkids, that now you want to leave a specific gift to them that you didn't know them before? So those kinds of things. So about every 7 years, But in addition to that, if you have big life events like births, deaths, divorces, marriages, where it might change who you're ultimately leaving things to, and anytime you have a major life event, it sounds silly, but think about, does this affect my estate plan? Does this, whatever's happening, does it change who's going to be the trustee? Does it change who's going to inherit? And if so, update it then. As far as updating it versus starting over, generally we want to keep the same trust, mostly because you've titled your assets in the name of this trust. This trust is a legal entity that owns this property. If you create a new trust, you actually have to transfer title to the new trust because that's no longer the same trust. It's like two different entities. Whereas if we just amend this trust, you don't have to change title. So depending again on your estate, as I say, I have some people that created a trust a long time ago, but nothing's titled in it. And it's really bad and we have to fix it. Let's just redo it. But if you have your house titled in it, any accounts titled in it, it's going to be a pain to change your title. So we will just either amend whatever provisions need to be changed, or the other thing we can do is restate it, which basically just says it's the same trust, same name, but we're just rewriting the trust itself. So that way you don't change the title, but the terms of the trust are current, up to date with whatever you need. So I do recommend that happens. Again, that's usually not nearly as much as the initial setup. The initial setup is the biggest expense of just putting the whole thing to get together. Amendments generally don't cost very much. I would say though, once you've done about 3 amendments over your life, usually I'll say at this point, let's do a restatement. Only because when you do die, the successor trustee have to administer this trust. And it's like this amendment changed this, and that amendment changed that, and this changed that, but this got rid of that amendment. And sometimes it's just so cumbersome for them to figure out what's the actual terms that every so often, rather than having all these crazy things going, I mean, you can do it, but it gets really difficult. It's just to restate it, bring it all up to date, get rid of all those old amendments, and now everything's up to date.
And if you need to start a new one, then you have to go back and cancel, or?
Well, you need to change title. So basically anything that's owned by the old trust, you have to transfer title out of that trust and into the new trust. Because as long as that trust owns something, it's going to be telling where that goes. So, again, anytime you create a trust, whether it's the first time or another time, if you're going to create a trust, you need to make sure everything gets moved into that. And that's just a matter of how you titled the account. Question. Oh, wait, went here and then you. Yes.
Yeah, mine is a follow-up to her.
Okay,
go ahead.
Okay.
Follow-up question, like, what if, the trustees and the beneficiaries, none of those are changing, but like you have new property or new accounts, is that covered under the original will? Or does the trust have to be amended? Or
Right. Okay. The question is if you have new property, everything else is the same, but you're getting new assets. That is not a legal change to the trust itself, so you don't have to amend the trust, but it's a matter of how you title those new assets. So you're going to title them in the name of the trust, and then the trust owns them. So you're not changing the actual terms of the trust, but you're just saying, this trust now owns this property. I've now titled it in the name of the trust. Periodically, or if we were doing another amendment, we would often amend the schedule that's at the back of the trust that says, here's what the trust owns. The primary thing that we always want to make sure is on that schedule is the real estate, only because that's usually the big asset. And the reason that we do that is if, for some reason, and usually this happens when people refinance, and I was telling Arnie today, I said, well, I haven't seen people doing this as much. He goes, yeah, people aren't refinancing as much. I thought, I thought they were getting smarter. They're just not around as much. But anyway, when they refinance, they take it out of the trust. And then when they're finished with the refinance, it needs to go back in the trust. And that's something people often forget. And that's what happened, like my mother, that's exactly what happened to my mother. She refinanced, and here we've got this trust, and her house is not in the trust. It's like, oh, great. So there is a shortened procedure at court. It still means court work, but there is a case, it's case law that says if it's on the schedule, it shows that your intent was to put it in the trust, and you've got some intervening thing like a refi that you can explain why it's not in the trust, the court will allow you to put it back in the trust and you avoid the whole probate. But it's better if it's in the trust. But that's the evidence that shows the court that if I didn't title it in the trust, but I put it on here, I meant for it to be in the trust. So it's kind of a fallback insurance policy if you did your titling wrong. But the thing that's controlling is how is it titled. when you buy that house, did you title it in your trust? Did you title it in your own name? So I always tell my clients, when you buy a new house, just call us and say, how was I supposed to hold title? I'm happy to tell you because people don't remember. You know, the main thing is you want to title it in the trust. Question here, and then yes.
Okay, so going back to the step up, let's just say it's the parents are deceased and then, you know, the beneficiaries are the kids.
Mm-hmm.
In terms of the step up, how do the kids pay the capital gains?
Okay, if the parents have died, then you're going to get that step up, and that's their basis. So if the house is worth $1 million when they inherit it, if they're selling it anytime soon while it's still, you know, it hasn't gone up, then there's no capital gains. But on whoever sells the house at whatever point, the IRS wants to know on the, whatever, I don't know the form, but on the form, what was your basis, what did you pay for it, or what was your basis, and what did you sell it for, and what's the difference? So they would say their basis is date of death, and then here's what I sold it for. So if the kids hold it for years and it keeps going up, then there is going to be potentially a capital gain on it. So it just depends on what's the sale price. Generally with the IRS, if you inherit property and you sell it within the year, they'll usually say whatever that basis was, it probably hasn't gone up, so you can use that as your basis, you know, the sale price. But if it's more than that, prices do change, and so you need to look at what was the basis a year ago when you actually inherited it versus now. And if anybody lives in it, again, they get that $250,000 write-off, but only if they're living in it. So if it's multiple people, they don't all get that write-off.
Oh, I see. Or if they decide to rent it out, then
Right,
it would
that
be
only
taxed differently.
Yes, because that $250,000 or $500,000 write-off is only for your primary residence, and that is with every resident. It used to be you had a one-time in your life capital gain write-off. You sell your house one time, and that kind of made sense. People held their houses a long time. It went up one time. You get to sell it and write it all up. Now what happens is you get that $250,000 or $500,000 with every house you sell, but you have to hold it for 2 years. So I can, you know, live in my house. I got this capital gain. I sell it, and I have less than $500 or $250, and then I move to the next house. As long as I'm there for 2 years, I get to write off another $250 for myself, or $500 for a couple. And then every 2 years you could do that. Most people don't, but you could. And if it's going up that much in value, you're doing pretty well every 2 years. And then you had a question?
Are these type of trust a recorded document?
Generally, no. No, we don't record the trust. You just record the title showing that it's titled in the trust. When you go to distribute out of a trust, that's when usually you have to turn in a copy of the trust to the assessor, because the assessor wants to know who's getting this, where does it say in the trust who's supposed to get it. And the primary reason for that is for property tax. Now we're talking property tax, not capital gains tax. For property tax purposes, the Prop 13 from way back, if it goes between a parent and a child, then the property taxes don't change. But the assessor wants to see the trust to see, does it go from a parent to a child, or does it go to nieces and nephews or whoever. It can also go from a grandparent to a grandchild if the intervening parent is deceased. But the other thing is, though, not only the intervening parent, but the intervening parent's spouse. So if you were to leave your house, say your daughter dies, but she was married, and you want to leave it to your grandchild, because that spouse is still there, you don't get that same Prop 13, which I think stinks, but that's the way it is. But it's Prop 13 for property taxes, going from a parent to a child. So that's the time when you would provide it. Again, it's not recorded, it's just sent to the assessor to look at that. But other than that, we don't record the trust. There may be times where they might, but generally we don't.
It was kind of about the surviving spouse dies.
Mm-hmm.
The children may not even know there's a trust.
Well, they would know there's a trust if the title, when they go to look at the title and they pull the deed, it'll show trust. And then when we have that all the time, with the kids, I have one right now. The kid is a hoarder, and he knows he has it originally in there somewhere in his
That's where
house.
I was going. How
And
do you
so
find it?
basically, if you can't find it, you have to go to court, and basically you're asking for instructions. It's like, we don't know where the trust is. We have no idea what it says. here's the most reasonable thing, we're all the beneficiaries, we agree this is reasonable, it goes equal between the kids or whatever, and the court will approve it. They're probably not going to approve it if you're trying to do weird things. They're going to go, oh, I can't imagine that's what mom and dad wanted, but you actually have to go to court to get instructions since you don't have the trust instructions.
Wow.
So the moral of that story is don't lose the trust or have somebody with a copy of it somewhere, because we've had that several times where people lose it. Yeah.
Or at least know
Like,
the
put it-
E,
lawyer who did it.
Exactly. Although sometimes I can't tell you how many times they've said, yeah, the lawyer died, or the
Yeah.
lawyer's not in business anymore. I'm like, okay. So, question in the back.
Yeah, it's just to piggyback off her question 3 questions ago, which is a scenario where you have the heirs, right? So the probate court did a appraisal.
Yes.
The property showed 1,800 square feet.
Right.
We've been working to get it up to the correct 4,000 square feet.
Oh.
They have a value, so the court's coming in, so this is gonna affect them on the step up, right?
Right.
Because they're valuing the property at 1,800. So is there an appeal where you can go to the probate appraiser and say, look, you're valuing this property at 1,800.
Right. You've made an
Really,
error.
here's all the permits and everything. Now we got it up to almost 4,000 square feet. A property's gonna sell for a lot more, and you valued it a lot less, therefore affecting their.
Okay, so he's asking about the value that the probate referee, when it goes through probate. So when it goes through probate, the process of getting it appraised is through a probate referee. This is a person that's trained, most of them are realtors, but anyway, they appraise the property at the date of death, and then that's your cost basis based on the what the probate referee says. If a probate referee has made a mistake and you know it during the probate, you would go back to him and say, look at your numbers again, you did something wrong. Once that probate is closed, and now it's been distributed, and you're saying, wait a minute, this wasn't right, you can potentially go back and get a new appraisal based on comps at that time and show that, that was an error. So, so again, you're showing that there's an error. It's just the process of how are you going. You can potentially go back to that same probate referee, or you can get another appraisal based on comps. It's a legitimate appraisal that shows that that was wrong. Now, if you're talking about after, either during the probate or after the probate, they've actually improved the value, that they've actually done work, that's different, because now you have that value. But if they've enlarged the house from 1,800 to 4,000 square feet, then you've got all the costs of the actual work that comes off. So you've got your value that the probate referee set, then you've got the costs of all the improvements that made it bigger, and then you've got whatever the current value is.
No, that wasn't the case. So it's still
Okay.
it's still during the probate course. So we could go back.
Absolutely, we've
to
done
the
that.
referee.
I had one lady, my client, she was a little crazy, and she got mad because they were counting it too high or too low. I think it was too high. She says, oh, it's in terrible shape, and blah, blah, blah. She made the probate referee reappraise it, went down by like $50,000. I just thought, whatever. It doesn't really matter. But in her case, she really cared. But generally, you can work with them. If you tell them, I don't think this is accurate, and here's why. It's really 4,000 square feet, or it's in really bad shape, or whatever. There's some reason. Then they will. They're usually pretty fine, and usually they don't charge any extra, because they get paid for the initial appraisal, and if they've made a mistake, they generally won't charge. There's always help out there. If you ever have a question, feel free to call the office and say, you know what, Julie was telling us about this. Is there something I should be telling people? We're happy to, to work with people and give you a little bit of advice if you need it. Okay?
So, just because we work with a lot of young families, and sometimes this doesn't even cross their mind. Like,
Right.
normally, typically, how long does it take to start up a living trust? And it doesn't sound like it's complicated.
It's not. Our process generally takes about 3 weeks from start to finish. They come in, we'll talk about it, figure out what they need, and then if they decide to go forward, it's 2 to 3 weeks after that when we can actually have the documents prepared. They sign them. As soon as they sign them, they're effective. So it's a pretty quick process and not super painful. And with young people, if they've got kids, and one of the things we do is we nominate guardians in case they were to die or become incapacitated, who's taking care of the kids. So there's other documents. I just kind of went over the basics. But for young people, again, avoiding probate, yes, the likelihood of them dying is low, although, people do die young. We're seeing stuff, and people are getting dementia in their 50s, and some even earlier, and then as a nurse, I can remember one guy. He was like 40, and he got the flu, and then from the flu, he developed a blood clot, and he had a stroke, And he was like 40 years old, maybe he was 30, I don't remember, he was young. But, you know, stuff happens. Car accidents. I can't tell you, I mean, how many people, you know, motorcycle accidents. Anything can happen. So, you know, I always just encourage everybody, have an estate plan. However simple or complicated it is, it's not that much money and it doesn't take much time and it's really not that difficult to do. And the alternative, if you don't, can be really, really ugly.
Thank you.
Sure.
Thank
Okay.
you. Thank
All
you so
right.
much.
Well, thank you all for coming. I appreciate it.